This is a very special program to many of us because it deals with a iconic decision written by someone who helped cultivate the relationship that the University of Pennsylvania Law School has with the judiciary, who's former Chancellor William T. Allen, who's a professor at NYU. It is fitting that we are working on an oral history project that we celebrate and look at the significance of the Caremark decision, which is approximately a generation old this year, and a very special group of distinguished practitioners, several of whom are quite dear to Chancellor Allen, have joined us, and who are ideally positioned to really bring to life this interesting topic. And what we're going to try to do is to move somewhat historically and to actually look at the impact that Caremark had in real time, trying to put ourselves back. For some of us, I don't know what decade I'm either in the 1970s or 1990s. Some of you have other decades, so I always refer to 1998 or whatever, but this really is in the 1990s and when it comes out. And Cy is going to act essentially as a co-moderator with me to be the sort of interlocutor, and I'm going to start by introducing him. Cy Lohr is the Vice Chairman and Chief Legal Officer of Millennium Management, which is an intergalactically large hedge fund with I think 34 of the name of a TV series or something like that under management. He's also apparently the global head of some hedge fund organization that's hangs out in London, and so Steve Lamb and I are wondering why we haven't been invited to share our thoughts in London with you, Cy.
You can arrange
but before that, Cy, among other things, was general counsel to the Securities and Exchange Commission, a partner at Munger Tolles, played a key role in the compliance program at Solomon at a key time, and was global head of compliance at Citigroup, and is ideally positioned to really lead us through this as having probably been regarded as one of the nation's premier experts on legal compliance and ethical corporate culture for a long time. Next to Cy is a wonderful person who survived a clerkship with an iconic Third Circuit judge without suffering death by garrote. She clerked for Judge Hunter. We can share the story after dinner and at some point, but many people got to see the garrote. But Janet is now the general counsel of Conoco, but she's previously been general counsel of Sara Lee, I believe, was it Kellogg's, and a partner at major law firms, and just one of the more special people in the legal community, and a person who's been a leader in this area for a generation. Next to her, continuing again our tour of Third Circuit greats, Dick Walker was a clerk for someone that we're all very proud of in Delaware, and our late great Justice Judge Seitz. And on the Third Circuit, Dick was the head of not only general counsel of the SEC, but was the head of enforcement at the Securities and Exchange Commission, and had spent a long time and don't blame him for it, but a long time as the general counsel and a high-ranking officer of Deutsche Bank, and is one of the most thoughtful and scholarly commentators on this area, and a real gentleman. We also have a Delawarean. I don't know if he'll call himself a Delawarean. We'll claim
I've been there
him.
long enough, yeah.
It's Michael Riley is the Chief Compliance Officer and Associate General Counsel of a small little corporation called FMC with a big building near here. It's actually a very major corporation. Before that, he was at Zeneca. He's a graduate of the Harvard Law School, and he is a proud Delawarean. He has a particular focus in environmental compliance. So one of the things that we tried to bring together today is there's a real range of industries each of our panelists has been involved in. And, I mean, Janet's been all over. She went from using the petroleum products to make the iconic Sara Lee cheesecake to now actually using them in a straightforward way. But seriously, there's a range of issues from environmental, pharmaceutical, financial compliance. They're all dimensions across which Caremark applies. And so what we're going to start with in real time is to ask, and I'm going to start with Cy, to actually focus back about when Caremark came out, and then turn to Janet to each reflect a little bit about what impact it had in this area when it came out to the decision, and then we'll move together forward with some more specific issues. Cy?
Thanks, Chief Justice. When I was thinking about it and getting ready for this session, I went back, as one would expect, and reread Caremark, and I can't figure out why it had the enormous impact it did. If you read the case, the Chancellor starts out saying, I mean, it's a case approving a settlement. And he starts out saying, I'm dealing here with the facts as best I can discern them, but I don't have a litigated record. And because it's a settlement, both the plaintiff and the defendant are endorsing it, and nobody's arguing the law to me. And so all of that's in the first 2 or 3 paragraphs. And then he goes on and one might say shoots from the hip. And it's all, by his own statements, dicta from the beginning. And I thought about it, and I said, you know, if I had just been reading what we used to call the advance sheets, and this case had come down when I was, say, a third-year law student and knew something about the law, but purely from an academic perspective, or even if I'd read it when I was teaching corporate law at this law school 40 years ago, I might well have sort of read it and discarded it. I mean, here's pure dicta, and yet it had an enormous impact. And I cannot tell you why the things I think of, obviously the role of Delaware within corporate law, and I was not then and never have practiced in Delaware, but the role of Delaware in corporate law is obvious to everybody in this room. That's part of it. The enormous respect that everybody had for Bill Allen has to be a part of it. I think there was a thirst in the community of which I certainly was a part, the broader compliance / corporate governance community, for some kind of standards that would talk about what directors are really supposed to do. We had at that point Smith against Van Gorkum, which had promptly been substantially reversed by the Delaware legislature. And I think those of us in the compliance, corporate governance business were looking for standards so that we could say to a board of directors, here, look at this, you need to pay attention to it. Probably some other factors, but everybody I know who was alert in the field got a message out to the boards of directors that they represented or were associated with and said, look at this important decision. And as an academic, you'd say, what are you talking about, important decision? But in fact, it has been an extraordinarily important decision. Simply, and people talk today about Caremark duties. Caremark has become the brand name for corporate directors' duties. If you read the opinion, there isn't a lot of law cited by the Chancellor. He cites to the Alice Chalmers case and derives something from the strength of that case, but not really very much. It is mostly a very well-respected jurist in a very important state saying, here's what I think the duties ought to be, and we'll talk about this later, enunciating them in a way that between the lines said to directors, you don't really need to worry too much about damages. We're not demanding a lot of you. But people took it very seriously. I took it very seriously. Everybody I know took it very seriously. And it has been an extraordinarily important case and a valuable case for all of it. Jen?
Well, I agree with everything Si said. I also, being the student that I am, went back and read it and said, what was so big about this case? But as I take myself back in time, there were a couple things, and one of them was it was coming out of the Smith versus Van Gorkum. So I think the part of the decision that said to directors, don't worry, we're not seeking to hold your pocketbooks to ransom, was very important. I think the other thing that's important is, as you look at the evolution of boards of directors over time, back in the 80s and early 90s when I was working with boards, they really were friends and sounding boards. They were people that management liked to have around, they liked to talk to them, they liked to get their view on things. They did not see themselves as having any auditing role whatsoever. And if you look at Caremark, it reveals that mindset, the idea that the board of directors is called to action at very, very seminal moments in a corporation's life, a merger, a sale of major assets, very few and far between times. And what Caremark said that I think was so earth-shattering was, no, you do have an ongoing duty to inform yourself about what's going on in the corporation. You're not just there as management's strategic sounding board. And that was a very, very major shift in the role of the board. And I think that it was starting to happen, but Caremark gave directors who wanted to have the ability to peek inside what was going on in the corporation without appearing to be snoopy, a reason to do so. It gave people who were in a corporate governance or compliance or corporate secretary role an ability to say to the CEO, no, 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 we've got to have a presentation on how we comply with the law and how we make sure we do, because Caremark came out. So I would say its value was almost more in the fact that it didn't scare people and in the fact that it enabled people who were searching for a way to be a little more involved an avenue.
Can I ask you too, before we go on to a little bit to the next topic, can we get Dick and Michael involved, is on that point, Janet and Si, how did it influence, in your view, the real-world compliance structures of corporations, and in particular, the institutional importance and clout of a group of people that you kind of collectively represent, which is the general counsel?
I think it helped a lot. I mean, I felt like it gave me a whole bunch of new arrows in my quiver. I was a general counsel at that point. And just being able to say, we have to have a program that we can explain, we can put on paper, we can memorialize for the minutes to protect the directors, gave a lot of impetus to actually doing that program.
I think that's right. And an important part of Caremark was the underlying corporate conduct. And Caremark, without going into it in detail, had gotten itself in trouble with the government and ended up paying a fine of $250 million back when that was really a lot of money. And recognize that directors come to board meetings 6, 8, 10 times a year and pay attention, but they're not living and breathing the company day in, day out. And what part of what Caremark said was, if unbeknownst to you, something's going on that really shouldn't be going on, and the company gets in real trouble, then we're going to really look at whether you were satisfying this duty. And since you don't know whether the company is doing something that could cause it to be in trouble, if you're thinking at all, you say, I better make sure I satisfy that duty all the time. And I think Janet's absolutely right. This gave typically the corporate general counsel, but others in that realm, the sort of muscle within the boardroom to say, you guys need to pay attention. because you don't know what's going to happen to the company, and if something happens, you're going to be, at the very least, in an embarrassing position.
Well, what we'd like to do is get everybody involved now and talk about this topic, which is, there's sort of, everybody is aware, and I think Janet mentioned the Van Gorkum dichotomy, and I think some of the students may have come aware that, and I think the practitioners know, is that Chancellor Allen was not exactly an unadulterated fan of Van Gorkum, and I think it's not clear that every academic is able to read Caremark in the sophisticated way Bill did it, but he basically gave everyone, Michael and Dick, an exculpatory charter clause, including, frankly, officers. Because if you read his opinion, you can't be held liable in the monitoring area unless you essentially act with a form of scienter. And I was wondering if you two could, and Cy's going to lead us through, talk about how does this dissonance work in the real world? Has it affected your ability as general counsel and to get boards to focus on this, that you can't use the damages club, or has it been productive that it's an area where they see as an important part of their duty, but not necessarily one where they can lose their personal wealth?
So I guess from my perspective, I've spent most of the last 25 years on the federal side of the ledger, not the state law side. And I see a sort of slightly longer horizon in terms of the impact of Caremark, but a very distinct impact nonetheless. Sometimes it takes a crisis to affect the status quo. And if you remember back in 1996, we were in the middle of a wonderful bull market, right? The rising tide floats all boats. Everything was going great. Certainly, I had just moved to Washington with the SEC, and historically, the commission has brought very, very few cases against directors of public companies. But during the beginning of the century, we had, in short succession, sort of three cataclysmic events. First, the dot-com bubble burst. Second, shortly afterwards, there was sort of the Enron era of financial frauds and cases of those sort. And then finally, 2007, 2008, we had what some would say is the worst financial crisis in history. Others might say it's not as bad as the Great Depression. But three events that really sort of rocked the world and caused people to, I think, ask an awful lot of questions. How did this happen? What could have been done to prevent this? Who was accountable? Who was responsible? What could have been done differently by all of the players, by boards of directors, by management, by regulators, of course. They were not immune from criticism, too. And if you trace sort of the thoughtfulness of Chancellor Allen's discussion of what directors are supposed to do, going back to '96, you see a lot of the same issues sort of in play in response to these crises. And the result was a lot of very prescriptive legislation of what needs to be done within companies, within boards. You've got Sarbanes-Oxley, which was passed very quickly after the Enron series of debacles, including requirements that your audit committee have a financial expert. So here's one very prescriptive piece of legislation that's designed to say to the board, you've got to pay attention. You've got to have the right people, that are overseeing this. A number of pronouncements even later by the SEC that fund complexes and mutual fund advisors have to have chief compliance officers, right? Again, to facilitate information flow up to the board, up to the people who are supposedly responsible for the oversight. So over time, there has been an enormous growth, sometimes not, ideally without the help of a crisis to push people to reconsider these issues, but nonetheless, some may say it's far-fetched to trace this back to the Caremark decision. I don't think it is. I think Caremark really triggered a discussion, an analysis of the kinds of duties and roles and responsibilities of what directors do need to do, how they fulfill those responsibilities. And in the worst of times, obviously, those issues bubble up, and I think the expectations and the requirements have changed. And so when people passed Sarbanes-Oxley, did they attribute any of the legislation to Chancellor Allen, to Caremark? No, they didn't. But I think you can see the same kinds of analyses that really have carried us forward and have become more and more prescriptive over time on the federal side in so many different ways. Possibly,
Can I ask you a question
Yeah.
before we kind of go on to like the interaction of this? Before we got that overlay, and same with you, Michael, and everybody, how did it, I mean, did we need that overlay to get boards to take this seriously, the federal overlay? I mean, how did it influence the discussion, and how does it influence the discussion that the damages, hammer is pretty difficult to get hit by?
Well, I guess-
Is it harder to get the attention of a board around the state law stuff, or did it take some of this federal stuff to actually make Caremark resonate?
I think that certainly the federal developments have made it much more relevant. Obviously, there's a high standard to Caremark before directors can be found liable or accountable. Now, I think most responsible directors are going to be very concerned about this sort of Damocles hanging over their head. They're not going to be parsing the difference between sort of negligent or intentional conduct. They're going to be worried about that. That's going to definitely influence behavior. But when you look at some of the remarkable behavior within boardrooms that we learned about, I'm thinking about the Hollinger case, for instance, that was described by one of my former bosses as a corporate kleptocracy, which was a great term. And when you looked at the actions of the board and the audit committee, they were just totally asleep at the switch. They were non-existent. It's one of these wonderful situations where the board was stocked by pals of Conrad Black, and they were ill-suited for the task, and they performed no visible oversight. So there were a lot of, I think, examples of that existed until they were exposed, became more transparent, and the consequences of not taking action were ramped up.
Yeah, if I can just add to that, I think it's hard today when I talk to our board to distinguish, they don't mention Caremark per se as what motivates them, but board members that I've encountered certainly are very concerned about making sure they know what's going on, that compliance is definitely part of their regular vocabulary that they want to talk to management about. When I think back to when I was an environmental practitioner when Caremark came out, I was not in this field, and yet I heard about Caremark. And the other thing that I think that was at that time, and it was cited in Chancellor Allen's opinion, was the sentencing guidelines, where that was set up as a framework and referenced by him, where that was a new, very important document that also came out that said that there was going to be a mitigating factor if compliance programs were established. So the two of those together, I think, kind of created the compliance mindset and discussion much more forcefully within companies, I think reaching up to the board levels eventually as well. And then all the additional federal legislation coming out of scandals and
Michael, I was going to
whatnot.
ask you precisely because you came up, as an environmental lawyer and have been in some of the non-financial compliance space, is that an area where Caremark has been particularly important? Because, a lot of what Dick is talking about is the Sarbanes-Oxley sort of DoddFrank focus on this, but I'm assuming in some of the areas you're talking about, even if you look at a Caremark as a case itself, which was about, sort of manipulation in the pharmaceutical industry, when you were in the compliance-specific space, did you feel from above that you now had more salience when you were talking to your business units about some of these issues because of this?
Yeah, certainly increasing enforcement from the federal level, but I think increasing awareness from the board as well in terms of the importance of their job to make sure that the company does the right thing, not necessarily that they just take management's word on it, but there actually has to be some regular reporting to the board to make sure that the systems that the company has put in place to stay in compliance with, waste disposal law or air pollution law or other requirements that might apply to a particular company. That was something they were starting to talk about, and I, having not been talking to boards before Caremark, I don't know if they were really talking about that before. It's certainly an important topic regularly on their agenda today.
And just before we kind of toggle, because I know Mr. Walker is anxious to get into into this century with the thing is, how did it, can each of you, including Sai, talk about, did you find yourself actually having more time with the board or more ability to get to the board after Caremark, even before, if we can focus pre-Sarbanes-Oxley, that that there were actually time for general counsel or compliance units to actually get board level contacts that there weren't before?
I'm going to say yes and no. And we're dealing 20 years later, and memory fades, and I could be a little bit wrong, but my recollection is that because you had the ammunition of Caremark that Janet talked about earlier, you could force the board to give you more time, and the board would be willing to do that. I don't remember having directors saying, I heard about this Caremark decision, can you talk to me about it? I do remember sort of saying, you people need to listen to this because we're talking about your personal liability. And we say personal liability, and as the Chief Justice pointed out, as have others, Caremark goes out of its way to say the likelihood of monetary damages is not great. But in a law school kind of setting, we often make the mistake of looking at a case and thinking winner, loser. If I'm the winner, I'm okay. If you're a director and you're looking at Caremark, or I put the Walt Disney litigation in the same category, you look at those and you say, I won after 5 years of litigation and depositions and being nervous and hiring lawyers and wondering how it was going to come out. I don't want to be there. I don't want to win the case. I want to not have the case.
I agree with that, and I would add to that, that I think, in my experience, directors are really not that motivated by risk of personal liability. They have insurance, they have indemnification. You know, people don't worry.
They care about making sure they have insurance.
They do care about that, and they should, you know, but I don't worry before I cross every street, will I get struck by lightning, even though I know it's a possibility. I think they kind of see personal liability the same way, but what they take very, very seriously is what could be a stain on their reputation that could cause them not to be an attractive board candidate for other boards. And so, to Sai's exact point, winning is not winning. Being in that case is not winning. So they want to have things in place that can be pointed to that will make people go away. And I'm not sure I would say I got a lot more full board time, but I got a lot more committee time after Caremark.
Well, and I think we're going to turn now a little bit to the topic of what did, when we had the turn of the century, right, and Sarbanes-Oxley, the whistleblower things in the exchange rule, how did that, you know, has that essentially eclipsed the importance of state law in this area? And also what would be interesting, I think, is to know from you as general counsel, because I think part of what we were talking about, Janet, too, is when you talk about boards of directors, or Sais is talking about boards of directors, you can kind of use it as scaremark a little bit, right? Which is, the fact is that the reality is you can be held liable, which is Bill Allen made it clear that there's a theoretical case. There are ways to talk about clients which can make it more or less scary. Outside law firms wrote a bunch of entrepreneurial letters. I mean, one of the things you forget, some of us may remember when the economy tanked and the deal economy tanked in the late, you know, in the things, some people started using this to get business, right? They would write and say, you should crank up the compliance program. We're not doing deals. What a great time to hire us to come in and give you the good Caremark colonoscopy. But does Caremark matter after this? And in terms of the sources of law, it could be interesting, you know, because you're an expert on this, is a lot of what we call Sarbanes-Oxley also is exchange rules. And so what has changed, you know, does it matter what the source of law is, and is state law as big after this?
It does. I view sort of Caremark and exchange listing requirements, Sarbanes-Oxley, all of these things as an arsenal of either carrots or sticks. And some of them are bigger than others. So when you're confronted with the possibility of Justice Department, investigation with criminal overtones, all of a sudden the prospect of a shareholder derivative action becomes, not so big a deal to you. So certainly, I think things have escalated and escalated, very substantially since Caremark in terms of the kinds of consequences that can befall corporations if they don't, have vigilant boards who provide proper oversight and proper monitoring. Does it mean that, the Caremark duties, are no longer relevant? I don't think so. But I do think that there has been not great inflation, but certainly inflation of consequential outcomes if you don't do what you're supposed to do. And that has, I think, been largely attributed or attributable to actions and activities on the federal side.
I disagree with that a little bit, Dick. I think you may be overreacting to your own background in which you had the government looking over your shoulder 24 hours a day.
Correct. Financial services is certainly kind of awful
Right.
one.
And particularly the banks, as opposed to the less highly regulated financial services institutions. I'm going to say in the ordinary corporation, the threat of government action isn't all that great. The fear of government action isn't all that great. The fear of shareholder action is a much more real possibility. Shareholder cases coming down all the time, and you worry what the proxy advisors are going to say, but you worry about the Delaware corporate law kinds of concerns more than the federal kinds of concerns. You just don't have, if you go down the government cases involving boards one way or another, they're all in the highly regulated industry. I don't think of one in a manufacturing company.
You've got the whole FCPA, load of cases, and that is a
FCPA
terrifying
the
prospect
Foreign
for
Corrupt Practices Act
any
is a different.
multinational company, the prospect of
That's fair.
a DOJ investigation.
But in terms of duties of directors, and actually Caremark had federal government enforcement action underlying the conduct that gave rise to the challenge to the director's duties under state law. And I think FCPA has some of that as well. I think the board is cognizant of its Caremark duties to make sure the corporations in foreign corrupt practices compliance. I saw a case out of California in the last 2 weeks that found, on a motion to dismiss, found directors might have individual liability for a whistleblower case under Sarbanes-Oxley or DoddFrank, some combination. But we pay attention to the state law consequences of the federal law violation in the ordinary.
Well, and Si, I think you make a good point. It'd be interesting to hear from Janet and Michael, because in the federal overlay of Sarbanes-Oxley and the exchange rules was heavily financially driven in terms of board composition. For example, I've always been worried since then that, a lot of companies still have the audit committee as the soup to nuts compliance committee. And Sarbanes-Oxley, for example, came up with the financial literacy standard, which actually could have the effect of excluding out a labor, environmental, or health expert who might say, I don't want to sit on a audit committee if I have to certify that I know GAAP. There's no requirement, by the way, that the people who sit on the audit committee who know GAAP know anything about health or food safety or labor safety. And I was wondering, from the two of you whose companies were outside of that space, whether there were any pressures from the rigidity of Sarbanes-Oxley that actually, in a way, undercut what Caremark was saying, which is, let's look at the most important compliance risk of the company and trying to address it. And because you two both have dealt with non-financial companies.
Well, for me, the interesting thing is when Bill Allen talked about the need to get information and oversee things, he talked about legal exposure, but he also talked about business exposure. And I think that kind of gets forgotten out of people's view of Caremark. it was actually after Dodd-Frank, when there was this pressure for all companies to have risk committees, that we sat down at ConocoPhillips and said, a risk committee makes no sense in an oil and gas company. Everything we do is risky. So what do we want to do? So we assigned oversight of certain responsibilities, largely the financial, some of the legal, compliance to audit, oversight of the health and safety and environmental responsibilities to our public policy committee, responsibility for executive compensation risks to. So we assigned clear responsibilities to each committee, and then ended up having a meeting at the end of each year with each chairman to get together and talk about how did we do, did we check the boxes, what are we worried about next year? And just having some blank space for people to talk about what's coming up, we found to be very useful. So I would say we worked around Sarbanes-Oxley and Dodd-Frank.
But wouldn't you say that very many, I mean, it was very prescriptive for bank holding companies, right? You have to have a risk committee.
Right.
But optional for others.
Right.
And my sense from the sort of burgeoning world of enterprise-wide risk management, that many, many companies, not just in the, financial services space, have decided that, risk is a big, gnarly category of issues. And even the New York Stock Exchange listing requirements say there's a specific requirement that the audit committee discuss and regularly deal with risk management issues. And I think many have sort of said it's probably good to house that. The audit committee's got a big job. It's got a, fulsome agenda of things to do. And I certainly found that, even though we had to do it, I certainly found that the establishment of a risk committee, in a foreign bank, made a lot of positive.
But that's because it's a bank.
Yeah.
Do we do anything riskier than drill a well 2,000 feet
Right.
under the
Yeah.
ocean?
Yeah.
Oh, that's not risky.
Yeah. And all we do is
And I
sell
think,
derivatives,
people
right?
in
So,
Oklahoma love daily earthquakes.
Exactly.
No, it brings to life the Carol. Their theme now is "I feel the earth move under my feet." And, but Michael, I was wondering seriously about this situation, which is, you've been in companies that were pharmaceutical, environmentally focused. Did you find, for example, because the Sarbanes-Oxley mandate for the audit committees was actually focused well beyond financial companies? Did you find that there was a period where, honestly, it was a little bit harder on some of the non-financial compliance issues to get focused because the board checklists had gone longer, and when you have a federal mandate for a checklist, and that comes first regardless of whether it's central to the business?
Yeah, in the immediate aftermath of Sarbanes-Oxley, everything was about checking the box, and it was, our poor financial colleagues in the company were really under the gun, and KPMG and other Big Four accountants made a lot of money. Fortunately, that's become a little bit more manageable right now, but it was hard to get bandwidth because there's only so much management attention, director attention that they can pay to other issues. Fortunately, we didn't have any crisis to force that attention, but I think the good thing about those experiences, though, is that they did force directors to look at, there's the need to set up some processes, and as bad as the checklists were when they first came out, it did force a certain behavior to which we can now say, if we take some of those approaches of looking again at other compliance risks, how do we look a little bit more skillfully as opposed to ad hoc at how are we looking at our environmental program, how are we looking at our regulatory compliance program with EPA or FDA or some of these other agencies that are monitoring our business to make sure we're on track. And it forced us to make better decision-making as business managers and also talk to our directors in a more coherent and, I think, productive way.
Well, maybe this is because this is controversial, because right after Sarbanes-Oxley, we had American CEOs essentially, trash-talking their own book. Well, what I mean is we had no, we did. I mean, reality is people went around the world and said that the world is ending. It didn't necessarily help. In reflection, how is this, you'd be interested to get in Cy, and Nick, you've been up to your eyeballs in it the whole time, or over, under the water of it. Have the more rigid requirements of the combination of Sarbanes-Oxley, the DoddFrank, and the exchange rules, because the exchange rules set up a lot of board structures, has an unbalance in each of your views been more beneficial on balance and justify the cost, or frankly a negative? And and is there a way to reshape the balance in your views that might calibrate things a little better?
Very hard to tell.
Yeah, it's like, what was it Daryl Dawkins said about women? Can't live with them, can't live without them. So, but you're going to have to make a pick now.
And one of the things, all of these things.
You remember Daryl Dawkins.
I'm trying to go past that comment. All of these things in a cost-benefit analysis, there are benefits. Some of the costs are hard to figure out. I mean, they're out-of-pocket costs, and Sarbanes-Oxley has been wonderful for the accounting profession and has generated much better auditing fees and that sort of thing. And that's one kind of cost, but one of the concerns people have expressed, and you just can't tell, is whether boards have become overly conservative, and whether people aren't taking the risks that in a properly functioning economy they would take, and is growth of the economy as a whole being punished by, you can't tell. And people will say that's what's happening. And everybody can point to an example where they didn't take a risk that maybe they should have taken, and maybe if they'd taken the risk, they'd be in bankruptcy today. I mean,
Well, our friend Joe Grunfest told me a military term that I'd never heard before, which is apparently what you do when you want to lull the top brass into something, that you put in this fancy PowerPoint, and they call it hypnotizing the chicken. And I guess maybe we should, and that, you put on the thing, and by the end of it, everybody's, oh, that's good. Is the three of you have counseled your boards. Is there a fear that they're just now hypnotized chickens, and the one thing they do at the end is say, make sure you've checked all the little boxes, as opposed to thinking deeply about the risks of the business itself, where are issues with boundaries with law, and frankly, where we can hurt people and therefore even hurt our stockholders? Has this been a big lulling machine that's good for advisors, or do we find actually boards doing a better job of surfacing company-specific risks and trying to attend to them?
Well, I'll jump in. I can say that I do think there are some hypnotized chickens as a result of this. I mean, there's no question about that the checklists of things that, boards will want you to do before taking action. We have a funny board structure for a German company. It's a two-tiered board system, but it got to the point where settling a lawsuit, there would be a requirement, check the box, 2 different business judgment rule opinions, elaborate memo, pros and cons to settle or not to settle, and a whole dossier, compiled of material to sort of protect your flag, which never existed before. I don't think it exists to the same extent in U.S.-based companies. But definitely, I think there has been a sense that we've got to lard the record, if you will, or at least make sure that the record is fulsome, so that these decisions are defensible when the time comes when we have to defend them.
Yeah, I thank God I've never worked in banking, but that sounds
No,
so
it's-
onerous. But, no, I think there's, a lot of it depends on the idiosyncrasies and composition of any given board and the membership of the board. We're fortunate to have a very active board that understands the boundary between business risk and compliance risk, and they do ask a lot of questions. We're a global multinational company. One particular hot area for them is FCPA, and they regularly ask us about that to make sure we're safe on that front. But, if we have a good plan to address that issue, they're going to endorse management going into a country which maybe is sketchy, but as long as we have the right plan, they'll support management to try to get that business opportunity to go into the Philippines or Indonesia or some other place. So that's an example, and I think the balance is just making sure how the board members participate and hopefully don't become hypnotized chickens. We don't have any, at least I've not seen them hypnotized.
I'm
I'm going to
certainly,
try that next time.
certainly on film, you'd be likely to disclose if you did have some.
And of course, I was speaking hypothetically and had
Can
no.
I ask, John, I want you to get in, but here's a lens on this that I think would be interesting for the audience to hear from the four of you about. One of the things that the exchange rules did was to create, Delaware had encouraged the use of independent directors, but in very particular spaces, like conflict transactions, internal investigations. But when you put together the exchange rules, they created a committee structure where, so-called gray directors, or people who had, you were either independent or non-independent. And you kind of understand that while you need an internal investigation, you need to have those hyper independent directors or conflict transactions. There's a lot of this area we've been talking about where compliance and business risk come together, and industry knowledge is important to actually the substantive function of the corporation. And I'm wondering how that has affected your guys' view of what board's doing, which is, are they actually capable of helping in sophisticated areas like environmental compliance, health, others, are they as useful in this? And have we gotten the balance between expertise and pure independence right?
So can I jump back to the last question for just one? Hypnotized chicken, it's just too delicious.
We do that in Delaware as a humane thing before we execute them.
So one thing that I feel really strongly about and jealously protect with our board is the white space of the annual chairs of the board, of the committee's meeting. White space for directors to just sit down and think about what they're worried about is the most scary thing in the world to the CEO.
I can't resist, but so did you have a meeting at the Trump inauguration?
We did not. But just a meeting where you don't have PowerPoints, you don't have an outline, people actually have to sit in there and think and talk is incredibly valuable. The other thing I would say is I think people underestimate the value of management presentations, even if they're boring and routine. Just knowing that you have to present to the board creates a discipline among management that gets things done. And you could have hypnotized chickens sitting in the chair, and it would be equally valuable to the corporation. So, what was your other question?
Well, the balance of the directors, which is to the extent we now have a situation where
Yes,
there are 3 or
independence,
4
yes,
committees
expertise,
that have to
yes.
be supposedly exclusively with these things. Does that mean when you're actually planning around those things honestly, the directors are not quite as substantively helpful in the discussions as you might like? And have we gotten that balance? Is it balanced right, or could it actually be recalibrated in a way that actually gave society better value?
So I've long been a proponent of a very controversial idea, which is that it's good to have senior operating executives on the board of directors, that a completely independent board is not a good thing. Because I think that nothing does more to create the imperial CEO, nothing does more to insulate the company from the board than to have nobody but the CEO have the responsibility and authority of being a director. So I would say I don't think this idea that just the CEO is the only non-independent board member is a good idea.
I want to jump in with a couple of things, and one is, apart from my day job, I am chairman of an audit committee of a publicly held company that is not in the financial services industry. We have, as a result of Sarbanes-Oxley and DoddFrank, sort of at every board meeting, 20 different checklists. And honest, I try real hard not to be hypnotized by them.
Right.
And I'm not going to admit to being a hypnotized chicken. But we do have 20 checklists. And before Sarbanes-Oxley and Dodd-Frank, we didn't have checklists. We had a board meeting. And that means we take up some time with the checklist, and when people are going down and checking it off, there's a question that comes up, and so we've been forced into that shoe to some degree. I hope not too much. I endorse completely your notion, Janet, on the independence, it has occurred to me sometimes that when people think about the ideal kind of relationship between management and shareholders, one of the companies that often comes up is Berkshire Hathaway. And everybody says Warren Buffett and Berkshire Hathaway is a wonderful company and they take care of their shareholders exactly the right way. And if you looked at Berkshire Hathaway's board before the imposition of Sarbanes-Oxley, it had no outsiders. Oh, it did have a law firm partner who was a partner of the vice chairman of Berkshire Hathaway and represented Berkshire Hathaway, and it had the vice chairman, and it had the chairman, and it had, you know, some very good friends, but it wasn't independent at all, and yet it behaved exactly the way we all want boards to behave, because there was an independence of spirit there, and you knew that Charlie Munger wasn't going to be at all hesitant to tell Warren Buffett that he thought Warren was nuts about something. Whereas, to your point, Janet, if you've got the imperial and imperious CEO and a lot of independent directors who don't really know the business, they're not going to say, I think you're nuts, Mr. Chairman. They're going to say, oh, okay. And
Well,
independence isn't all it's cracked up to be.
Well, no, and that's what we're going to talk a little bit of ideal structures, and I think one of the things that you're mentioning too is what I would call sort of the adult table at Thanksgiving thing, which is, you know, you're either at the adult table or the children's table, and part of what you used to get to see a little bit is the next group, and honestly, would they be willing, and frankly, how confident is your CEO to let the key subordinates speak their mind? But the other thing is, on banks, on the bank director on a lot of ordinary operating companies, there used to be somebody who, you know, there used to be a principal capital supplier, debt equity capital supplier for a lot of companies, and they often had a bank director. Well, that person came into the boardroom knowing the leverage of the company, and same with the longtime lawyer. They may not have wanted to take a huge amount of risk, but they didn't want the Titanic to sink. And I was wondering if when we look at where things are today, again, if there have been some good things and there's some things we could recalibrate, it'd be interesting for each of you to maybe talk in the financial and non-financial space about what you might do differently, what you think a board should look like, and then kind of what do you have to get out of the way of that? You know, for example, I would say I would always volunteer to serve on corporate governance because it's just a really onerous BS committee. And I'll let, frankly, Rob Spatz sit on audit. And I'll ask for equal pay because, you know, corporate governance is really important. But we do have these things, all these mandates. Are there things that we should get rid of to give boards more time? And what would you each do? Like, if you could set up the world side, what would you change?
I worry that because of the way Sarbanes-Oxley came into existence post-WorldCom, et cetera, and especially DoddFrank, we put much too much emphasis on financial reporting, which is important, but financial reporting, after all, is the one part of the corporation's activities where we do have an independent group, the auditors, looking at it, getting paid a lot of money to think about it, taking on liability to be troubled by it, and inevitably, if you're putting more attention on financial reporting, you're putting less attention on other things. Financial reporting is always looking in the rearview mirror, because we're not reporting next year's results, we're reporting last year's results. And I fear that we've put too much emphasis on that part of it, and it's at the price of people not being able to spend as much time looking out the windshield. Janet?
Well, I regret that we have made the board the kind of auditor of management. I understand the importance of oversight, but what seems to be forgotten in current discourse is no board really is going to save you from terrible management. And you don't, institutional shareholders ought not want to be meeting with the lead director. They ought to want to be meeting with the CEO and the heads of operations and the CFO and taking these people's measure. Are they honest? Are they honorable? Are they smart? They're the people running the business. I think we've lost sight of that.
Actually, Si, going back to your statement, in which I agree with, that there shouldn't be an undue emphasis on the sort of financial reporting and disclosure. I certainly think that in the years right after Sarbanes-Oxley, when the 404 requirements came into place and the certification requirements came into place, there was an enormous amount of expense that was occurred, enormous effort, and a disproportionate amount of focus and time in terms of getting to meet those requirements, which are annual requirements that you have to satisfy on an annual basis. I wouldn't say that they're now self-executing, but it's really embedded, I think, in a positive way. So I guess I would be one to say, were they good reforms or not? I think they were good reforms because I think they took public companies to a better level. But I don't think that the same amount of annual activity, focus, and attention is spent as it was getting to that level. I think that the embedded policies, procedures, and actions and interactions that occur well below the board level should make that much more streamlined. Now, one would hope that they do. And we haven't, I mean, for better or worse. I mean, is it the end of, financial frauds? No, it never will be. But have you seen Enron's, WorldCom's, all of that spate of things, which, you have to scratch your head and say, how in the world could that have happened with, as you say, external auditors, internal audit staff, and boards of directors? Those have noticeably sort of fallen off. So I say...
We went a long time before we found out what was going on
Absolutely.
at WorldCom, and there may be
Yep.
something out there right
One
now.
doesn't know what the ticking time bombs are, that's for sure.
Well, Michael, you're in an area where, you know scary stuff like the intersection of science and law. As this all these different requirements, has it made it easier or harder to frankly get directors on the board who can be useful to you and your fellow managers in, navigating some of these spaces?
Yeah, I think any company that's involved in innovation, be it chemical technology or perhaps IT or other forms of innovation, I think they do struggle to get people on the board who probably can add that extra value and insight and give assurances to some of the other board members who might be the financial expert or have the other perspectives, and be able to speak in a language that can be commonly understood and also challenge management and hopefully give some good ideas in the same time. So I think, I think we've been fortunate to find people who fit that bill, but it probably is a finite pool. And I think, how do you get people engaged? And people do want to be directors. I know it is possible to recruit, but getting people who have that right capability. And if you have to fill certain seats with certain designated experts, that probably does block your ability to bring in, fresh perspectives in other areas
Are
as
there
well.
2 or 3 things each of you, because one of the things that I think was not very mature about the post-Sarbanes-Oxley discussion was the lack of specifics on the part of those who criticized it about what they would get rid of. For example, the focus on 404 should have been rewritten, but 404 arguably should have been all of Sarbanes-Oxley done right, and the rest of the stuff was was extraneous. But for example, are there committees that you think we don't necessarily need to have mandated by the exchange rules? One minor thing I thought, Si, is, why do we have to have every committee mandated with independence as opposed to simply audit and maybe, compensation, but then require certain things to be voted upon by the independent directors separately at the board meeting level, but allow other members of the committee? Because I'm assuming part of what you all also have to do is, these people come into town and you have to use their time well. And what the rules set up also dictates your use of time. And so I was wondering if there were, just some calibrations, any policy ideas of things where you just say, as general counsel, why do we do this? And isn't this one we could get rid of to create a little bit more of, what did you call it, Janet? White space?
I think I wouldn't push getting rid of very much of it. I think Dick's probably right, except for the newly public company. Everybody's up to speed now. It is true, and the chairman in waiting at his Senate hearings last Thursday was talking about the costs to going public and that sort of thing, and that's still a real concern. But for most of the several thousand companies out there, they've gotten up to speed. They have the independent directors in place. It's working reasonably well. I don't see a lot of things that I would go back and say, gee, we really should repeal that. And other parts of it, of Sarbanes-Oxley and of DoddFrank are sort of sitting out there and maybe they're not doing much anymore. I think of the attorney conduct rules that everybody paid a lot of attention to in 2001 and worried about the SEC's authority over attorneys. That was 2001. This is 2017. The number of cases the SEC has brought against attorneys under the attorney conduct rules is exactly 0. So maybe it wasn't all that rough a thing, or maybe there's a case waiting in the wings to come down in 2 years that's going to have us all worried about. But I think at this stage, corporate America has largely sort of adapted, as Dick said, and is going on. I'm not sure there's very much I'd try to get rid of. I don't worry about it.
I wouldn't get rid of too much of Sarbanes-Oxley. I guess I've lived with it longer, maybe. But DoddFrank, I think, had some spectacularly bad ideas. You know, the conflict minerals rule has, by all accounts, increased depredations in the Congo. The pay ratio rule does nothing except try to shame people. There are a number of attempts at social engineering in Dodd-Frank that I just think are very bad policy.
A number of annual reports to the Congress from the SEC that we don't see very much, but it is soaking up taxpayer money for not very much benefit.
And when you, Janet, and everybody speaks to Sarbanes-Oxley, do you include in that the exchange rule mandates for board composition and for board independence? And that basically we've all lived, no, because it's important. I tend to view them as a package because they were, you know, honestly, we all know that the exchange rules were, before WorldCom hit, it was the hope to stop at the exchange rules. And then that's when it went from Sarbanes to Sarbanes-Oxley, because I still love Damon Silver's quote about Sarbanes-Oxley, where he said calling Sarbanes-Oxley is like calling Appomattox Grant Lee. Well, because if you remember Michael Oxley, it was the WorldCom debacle that switched the Sarbanes bill. The hope had been from the business community to use the exchange rules to get around this. And so I was just wondering, were you including in Sarbanes-Oxley the mandates for the committees and even the definitions of independence, that those things have all, because we also have companies that are below your market cap. You know, you guys are at large companies, but there are emerging companies in the public company space for whom some of these things are pretty difficult, right?
You know, though, I mean, one of the good things from the corporate side about using the exchange rules is that the enforcement is it would have to be increased significantly to be called lax.
So it's sort of, so it's in keeping with Caremark to use the exchange rules. It's admonitory.
Yeah, and the exchanges look at them but don't have any, there's no private enforcement. They're people do it, but don't worry about it very much. I don't know, have you,
No, I think you're right. You know, in terms of thinking about what's changed, I don't know whether you all would agree, but I think one of the biggest changes is that the job of being a director, the time requirements and commitments have increased astronomically. You don't just go to, you know, 3 or 4 meetings a year, you know, a couple of committee meetings, you know, on the same day. I mean, the time demands are quite substantial. And the information, what I would say is overload.
Yeah.
Is crushing. I mean, the routinized kinds of reports that are passed on up, which are impossible, I would think, for most directors to kind of absorb and, you know, get to the most important stuff. I just, you know, see this as a real downside in the name of, you know, reform to otherwise lax behavior. You've created, you know, kind of the opposite extreme where there's just too much information to be useful. And there's got to be a happy medium, or perhaps it's the way people prepare the information. To be comprehensive, you have to be exhaustive, and you don't just focus on the top 10 risks for fear of, having number 11 or 12 blow up, at a later time.
But,
So-
and I think that raises the bigger point, which is that, from Caremark through Sarbanes-Oxley through DoddFrank, we've increasingly adopted the model of the board as auditor. And the board is ill-suited to be an auditor of the company. And I think we kid ourselves if we think they'll do a good job of it. And I think stepping back and saying, what can a board do well? And I think your example of Berkshire Hathaway is a really good one, because in my experience over 25 years of watching boards, the best board members are the ones that management trusts so implicitly that they want to be challenged by them. And that has nothing to do with the whole superstructure of boards that we've created.
Globalization. How does this affect, the whole idea of compliance? We also have these words, right? I mean, it's hard to keep track of it, right? We still apparently want no MFG, but we now want ESG. ESG is the new word for being a socially responsible corporation. And, right, that's I forget what it gets into. But there are challenges in putting together a board of directors right now when you're operating in multiple markets. There's also the challenge of, heck, we could be in regions of the world where a lot of the underlying materials are actually sometimes in languages that we don't read. How is that, how is globalization stretching, your capacities and changing board practice?
Just for my company at least, it's, I think from just a thing about Caremark monitoring, the scope of potential problems that a company can get into has increased dramatically. Not only just by going globally, but many of these countries which in the past had very limited enforcement regimes, they're now beefing up their own enforcement. Could be antitrust, it could be environmental, it could be product regulatory. So it increases the range of things that directors theoretically have to pay attention to. Of course, they can't pay attention to everything. So maybe someday there'll be some case where something happened overseas and it creates a derivative suit. But I think there's a concern perhaps do they throw up their hands and say we don't know what, or do they just be selective and just press management in a monitoring kind of way? I don't think you can audit every possible compliance activity that a company has globally now.
Or actually worse, sort of view things if you're in a multinational company or a U.S. director, and you make the mistake of sort of viewing a problem that exists in Europe, Asia, through the prism and the lens
That's
of
true.
what you know and what you understand, and ignore sort of the local custom usage knowledge, boy, you're going to be in a huge, type of a bad
And there's
situation.
no bigger example of that than BP's reaction to the Gulf
Yeah.
oil spill.
Exactly, yeah.
They just didn't get it right.
Or
Well,
Volkswagen,
Yeah.
then.
Yeah.
On most boards I know, and the board I sit on, we've tried to have a collection of knowledge so that any kind of a problem, somebody will have some real expertise and be able to deal with it. As you move away from the United States, it becomes much harder to make sure you've got all of the instincts on the board that you want to have, and you quite often have flat-out conflicting compliance obligations. You've got European privacy restrictions that are in conflict with American mandates about what information you have, and you need to balance those, but it's very hard to figure out how best to balance it, and there's a judgment call, but you're not well equipped to exercise the judgment if you've grown up with, as Dick said, just the American instincts for dealing with it, or in BP's case, just the English instincts for dealing with the Gulf. And
That's an interesting point, because one of the topics we wanted to talk a little bit about was this idea of whether it's law and culture or law or culture, and how do these relate. And in the globalization space, it's a kind of interesting dynamic because we see people pushing Caremark claims. You know, what is the old, what's you know, I'm not a big Latin fan, but you got malum se, right?
Malum prohibitum.
And malum prohibitum, right? Which is malum se, I think, was in criminal law. The things that, you know, the things about.
Everybody knows her.
Well, no, but it's like, you know, I always love, I'm a big fan of Allison's Restaurant. The scene on the bench where, you know, after the massacre, and he gets arrested for the trash dumping, and he's on the bench with the mother rapers and the father killers, right? That's, I believe, malum se. But then you got malum prohibitum. But when in business things, frankly, I would think that despoiling the Gulf of Mexico or Prudhoe Bay is kind of malum se. Selling a product that could kill someone, malum se. But then you got issues like we've had a Caremark case recently that involved a thing like protecting intellectual property in highly contested spaces like, you know, I don't know, where if you take your device out, right, your iPhone, I believe there's about a gazillion patents that different companies claim are essential to that iPhone. And people are bringing Caremark claims against companies going, well, wait a minute, the Chinese competition authorities, right now, yes, you are allowed to giggle when you say that. The Chinese competition authorities have levied a $900 million fine on an American company. Well, it may be that they frankly had some of the best lawyers in the world, and that the only way they could actually find out what the rules of the game in that market were to actually try to protect their patent and deal with what's coming in. How are you guys navigating that, and how important then does culture come in, like, setting up the line of, frankly, this is on the ESG side, which is we know this is the malum se side, poisoning, other things, whereas the other side involves some legal risk, but these are the legal risks of navigating in a legitimate way in an uncertain world, you know, because that's a hard thing, because when you're directors, you know, we're starting to see people bring these, I would call them malum prohibitive kind of Caremark claims. And have you guys dealt with that? I mean, obviously, you're all about killing the environment, but some of you are on more, you know.
Not.
He helps.
Dick, I think that was for you.
Well, but how do you?
Oh, gosh.
No, but Michael, you do some of the intersection of this.
Yeah.
How do you determine when is, you know, when you get edgy, and do you disclose, you know, how do you deal with those things, and do you separate those things talking about? Because we are in a world where, frankly, regulatory arbitrage is important things. Governments, even the EU, frankly, uses some of the things about intellectual property. They use them in a protectionist way, and if a business is not assertive, you become a sucker. But how do you as lawyers talk to a board about those risks, and do you separate them, and how does culture come into that?
I think the malum per se category is the one that board members still are more attuned to, mostly because if something like that happens, that's going to be very easy for everyone out, you know, to be portrayed on the front page of the New York Times. That hurts their reputation. If it's something that's more of a legal compliance and it's a gray area and it's confusing, if that does become a problem, I think everyone can, from just a human nature point of view, said that's really complicated, it's some legal issue. They want to know about it, but I think unless it's potentially going to rise to a level of materiality that could really hurt the company, probably don't need to raise it because they just won't understand it. That'll be delegated management. But if it is a significant issue, then I think the management team and the general counsel has to bring that and present it as best they can.
Maybe again, it's a financial service idiosyncratic world, but boy, the importance attached to reputational risk over the past 8 or 10 years is just phenomenal. I mean, there's a board-level committee at Deutsche Bank, a reputational risk committee that has 2 board members sitting on it, and enormous thought and attention is given in the malum prohibitum category to whether this is the kind of thing that's going to result in a bad headline somewhere, and, you know, people, you know, storming in front of the stage at our annual meeting, which goes on for hours and hours and hours. So, and I don't think we're alone in terms of the, you know, the importance attached to the reputational risk category of, apart from, you know, what is or is not, strictly speaking, legal.
Well, part of what Si's though getting at, and it's like, do you sometimes have difficulty getting directors to take a legitimate disclosed legal risk, where, like, what I mean is, I actually believe if you're taking legal risk, that's where it's important not to hide what you're doing and saying openly, these are our IP policies, we're not ashamed of them. You know, if you're trying to hide anything, that's usually a sign that you're on the inside. But does the director specifically say, you know, frankly, if the stockholders are going to sue us when we try to protect our patents, and they're the ones affiliated with ISS and the Council of Institutional Investors, and we're in that network, you know, maybe we'll just take a little bit, we'll take a few billion less in EBITDA, and they can benefit from the South Korean and Chinese going publics in the IP space. Do you ever have any of those trouble with the directors where they're just not really going to step up to the plate because whatever, which way they go, they get sued? Or is that just a myth?
Pardon me, that's real enough. I was trying to think of concrete examples, and one isn't coming to mind, but it's real enough that people have to make the judgment call because they're at risk no matter what, and they simply end up saying, here's what we think we have to do, and if somebody sues us, they sue us, and if we have to duke it out, we'll duke it out. There are those. You willingly take the risk of some lawsuits. You willingly take the risk of a shareholder lawsuit way before you take the risk of a federal government lawsuit. Because the New York Times reaction to the federal government lawsuit is always going to be bad, and the New York Times reaction to the shareholders lawsuit is going to be less bad, so you're going to get less bad press. It's not going to be good press, but you make those calls.
A last point, because maybe we can get the audience in here, about the tensions that's, you know, the tearing fabric of the European community and the potential that each nation starts going much more its own way. What are the challenges that that's going to present for corporations trying to do business across borders and trying to do with them? Is it a good or bad thing? The EU, for all its imperfections, did at least give you a fairly large swath of territory across which there were predictability. How is this going to, how do you all foresee this affecting the jobs you do as general counsel and how you approach compliance?
It complicates life, but you've got several different aspects of it, and part of it is what does the whole world look like in 10 years? I'm one of those less worried about Brexit that's supposed to be triggered tomorrow, and because I'm not. The debate about Brexit tends to be positioned as Britain is leaving this wonderful union, but I think this wonderful union was falling apart anyway. So it was leaking, it was a leaking ship that Britain was leaving, but we won't ever know the answer to that. Britain's leaving makes it more likely that the EU falls apart too. But there's the EU as the trade group, which could get reconstituted. There's the Euro, which is a different animal and would fall apart with the EU, but lots of different currencies for my fund means lots of different currencies to arbitrage, so that's a good thing. Change creates opportunities and challenges, and we'll deal with them to the extent we have to.
But it's still sort of an indisputable fact that each of the members of the European Union has local law and local law requirements. So you're going to, under any circumstances, have to comply with the local laws of France.
As well as the European.
Yeah,
right.
and
Yeah.
the local laws can be, wildly different and not, consistent with one another in many, many different areas.
Yeah, I think if the EU were to break up, it would add a lot of cost burden, compliance burden, complexity to doing business, and risk to the companies. And in terms of our particular industry, as difficult as EU bureaucrats have been and to our industry in terms of their view of the chemical industry, to have to go to 27 26 different regulators across Europe, all who have different views, would be a nightmare. And so there's, hopefully, if it does break up, there'll be some pieces that will survive, but it'll be a burden, probably, more work.
Well, audience, we can get you in. Do you have some questions for our esteemed panel?
Or even for us.
Once assuming red flags have emerged, what do you actually have to do with the board action?
Could you say that again, a little bit louder?
Sure. Once red flags emerge,
Okay, once red flags.
just assume red flags emerge with billions of dollars in fines. What exactly does the board have to do in response to those red flags?
Respond.
Yeah.
And respond.
Situation
legitimately.
specifically.
Actually, the board has to respond when it sees the yellow flag.
That's what I was going to say.
Pink flag.
And be alert to it. When it's the red flag, it may be too late. I mean, resign. It's too late for that, too.
I think what you should do when the red flag is, we'll collect everybody's cards of your litigation partners.
No, but you're going to be judged in hindsight always. So the failure to take a serious and sober, response to a red flag, you're going to be doomed in terms of the tail end. So I think most people, in the face of a red flag, are going to, waste no time in putting together a very good either plan of investigation with the right people that are involved. I don't think in today's day and age you can just sort of shrug it off.
Can I ask a question, though, that is, I think, today's day and age? We all feel this, we as judges are amazed that people can opine what a 50-page opinion says within 10 minutes of its issuance, and then have professors actually debate the initial blog postings without reading the thing. How has the blog world, no, it really is true, and the academics have to admit it, you all rush to the media as quickly as you can, or at least there's enough of you who do, and the law firms comment, everybody comments, and no, there's fewer of them at Penn who do that, but there's a lot of them who do. And what is reality about a situation and what is the perceived reality are often difficult to untangle. How has that affected how you all practice? Because you've got to actually get to the bottom of things, but to try to set a tone that gives you some space. I mean, do you actually find people just running off the ship and not actually sticking to help the corporation deal with something that might, frankly, it might be bad, might be awful, but it might really not be the end of the world, but we don't yet know?
No, I really do think Dick is right. Once a red flag has emerged, the exit doors are closed. That is the wrong time to rush off the ship.
Well, what I'm talking about is how do you deal with the yellow flag that has appeared in the blogosphere, in the world out there, where, again, it could be that it turns out to be that you actually violated a real rule. But it could be, honestly, you just need to get to it. Is there more time pressure than it used to be? And how do you avoid moving to, frankly saying, it's really impinged on my family time to respond to the Gulf disaster, if that's the one thing, from overly pleading guilty and going out there and saying, we were a bad corporation, when it turns out that we weren't so bad.
You have to have a good holding statement and stick to it.
I think it's actually, the blogosphere isn't your larger problem. Your larger problem is your internal, compliance or whistleblower lines, or, people who can anonymously, for whatever reasons, file reports of things, perceived wrongdoing within your company. And boy, you got to get on those fast, quickly, and you can't ignore those because, as we know, the whistleblower, even if you do, could go to the SEC or other regulators. And boy, if they have to come to you and raise a problem that has actually been raised to you already and you haven't done anything about, it's not a good place to be.
Do you model these things in advance? Like, do you actually, as part of your compliance thing, do you actually have sort of contingency plans for the stuff that you're not sure what it will be, but you know it could happen, and how we're going to handle the first 24 to 48 hours?
I don't think it's a compliance issue. I think it's a communications issue.
Yeah, but it could become both, right?
Yeah,
Because it
but-
turns into a credibility.
Right. And it's a credibility issue with your workforce, first and foremost. Those are the people who really feel like their world has been turned upside down.
But it can also call, if you don't respond in an appropriately balanced way, it can also turn into external demands about how you proceed to
Right.
get to the bottom of it, because if people say the wrong thing, people can be recalling for their recusal, the creation of.
But there's
know
no,
what the right thing
right,
is.
there's nothing really to do except say, we've been informed of this, we take it very seriously, we're getting to the bottom of it. We'll be back when we've got something
You've
to
got,
say.
inevitably, you believe certain facts that turn out not to be true, and the example I think of in that context is Jamie Dimon in the early stages of J.P. Morgan's London Whale, where he came out, and I'm sure he thought and believed on what he'd seen, that this wasn't such a big deal, and you're making a mountain out of a molehill, and et cetera. And then it turned out it really was $6 billion that they'd lost. Well, he needed to respond because the rumors were out there, and you go with the best information you have, and I'm be reasonably sure he did, and it turns out to be wrong. How do you control that?
I think the more conservative holding statement, like Janet said, is now, in light of the, the tempest in a teapot kind of statement by Jamie Dimon, I think that's the norm that people are going to.
There was no mention of Stone versus Ritter, decided 10 years later. And I'd be curious as to whether you see that as an enhancement of Caremark or really a clarification. Because in Stone versus Ritter, the court purported to adopt the Caremark standard, but then talked about directors utterly failing to implement the reporting or information systems, or having implemented such a system, consciously failing to monitor or oversee them. And then when we wanted to say in either case, a position of liability requires a showing that the directors knew they were not discharging their fiduciary obligations. So is that Caremark on steroids, or is that just a repackaging of Caremark?
I've thought of Stone against Ritter as repackaging much more.
I thought of, I have to take some blame or credit for Stone v. Ritter. I thought it was to get rid of the confusing part of the triad. And, I mean, there's 6 of them missing because there was originally a triads, but it was the Technicolor decision that had this thing out there. I actually think if you look at that language, it's very true to the original Caremark. What was not understood about the original Caremark is Bill Allen did such a good job of writing that, like I said, many academics teach law students the case wrong. It's often taught as part of negligence-based liability, when from the get-go, he set up a standard. What he said, and I think what it was, is you basically had to, there's a three-letter word you had to do, and if you did it, you couldn't be liable under Caremark. Try. And it's when you knew, essentially, that you weren't trying to act as a monitor that you would be liable under Caremark. I think Bill Allen consciously set that up. I think one of the genius moves, and I'd ask the Delaware lawyers to think about, what kind of complaints would you be getting right now with all the pressure around 102B7 and its lack of coverage of officers? Think about the officer-based Caremark claims you would be getting if Caremark itself did not embody an exculpation. So I viewed it really as in some ways what Bill Allen was to hew to the best of our law's tradition, give it integrity, but to keep the ornate out, and that he wanted accountability in this thing, but frankly, he viewed it as an aspect of the duty of loyalty that you had to give an effort. And so I viewed Stone versus Ritter as being very true to Bill Allen's original principles. But that's just my reading. I don't know if Don Wolf or Steve or anybody who deals with it has a different perspective. Michael?
We just at the start of this, or is it
I don't see any slowdown in the growth of legal, well, maybe currently in the new administration, there might be a slowdown, but certainly the trend has been more and more compliance-oriented, and there's been an effort certainly to get managers and
I actually
boards.
want to, without anybody diming out a director or anybody, I'm very interested about the challenges that a deregulatory environment poses for corporate compliance staff, and whether anybody, and this we should get the audience in on it, whether you're hearing anything from directors or officers like, you know, why are we worrying about this stuff? This is yesterday's problem. Because I think it's a very challenging time, because the reality is, in the business cycle terms, the decisions you make today can turn, as we saw with Sarbanes-Oxley itself. The regulatory environment, all it takes is one disaster, and then it switches quickly. Are there some fixing, I'd like to get the audiences, where you're hearing from some people to actually say, well, you know, why are we worried so much about this? John?
Let me disagree slightly, and I think you probably agree with my modification of that. I mean, we've had the SEC broken windows approach, which I think has been counterproductive, because we're all going to have small violations that you can't avoid, and there's some sense, if the SEC is in fact going to chase down every small thing, you say they're going to come after something, and you may be less careful, should be on the significant things. Right. I mean,
How are the, and John and others, how are things like, does Caremark actually take on a backdrop of significance, sort of as a bottom in this environment as well, where you can point to state law? And I'm also asking about what the pressures, you know, I was joking a little bit about the ESG, but as you as people talking to folks who may not be, frankly, you know, they're business people, they may not be as interested in these issues, are you calling on things like the ESG movement and other things to say, keep this in balance, because there are other trends going on which are actually countervailing?
Absolutely.
Students, you're allowed to ask questions?
encouraged even.
Yeah. No? Larry Hammermesh?
Won't pretend, I'll be a student. I'm a new director. I come to your office and say, I heard the Chief Justice say that I have this fundamental obligation
Well, I think every company has certainly a new director training to orient them as to what their obligations are, and they listen attentively and ask questions, and hopefully they're educated. And beyond that, how much it sinks in, hopefully they learn by doing, and it's in their DNA. But I don't think we need to have them sit through a legal seminar to really understand the full history behind every particular obligation, but it's really more trying to make it practical for them. This is what it means in the context of the way we do business on our board.
Can you give an example? What would I do as a new director?
Well, it'd be an explanation of this is the way we operate. If you're on this particular committee, this is your particular responsibility. Please read the charter. If you have questions about it, let's walk through it together and really understand what we expect, how we operated in the past. These are the types of things that you should be expecting to hear about when you hear management present to your particular committee. And hopefully it's not just a one-way presentation, but they actually are engaged enough to ask questions. And that's where the real learning happens.
And an understanding that the kinds of reporting, the kinds of information that the new director is going to receive, show them copies, explain to them the format, what's included in these reports. If there's parts of them they don't understand, who is it that you can talk to understand exactly what this massive information flow is, and what do you do if you have a question or don't understand part of it?
But Larry, is your question, what do you do as a new director, or I'm new, tell me what I'm going to do as a director? Okay, then I think that's been answered.
I think, I think also you pay attention, fairly close attention to industry-specific news.
Yes.
And if you're a director of Ford and you see what happened to VW, you get a report on how our systems work so that we know we don't have some engineer going crazy because he's figured out a way to cheat the tests. And you find out what's going on in the industry, hopefully with other companies, but get a report from somebody that you think you can trust. And if you can't trust them, either they shouldn't be there or you shouldn't be there. But ask them what they're doing. I don't think you have to get down into the weeds and try to become an automotive engineer to figure it out for yourself, but you can ask for a report that satisfies you, and at that stage, I think you're trying quite well.
Professor Brown? it isn't part of the issue, Bill. I mean, I'd ask, I think one of the things to think about this compliance thing is if you assume, as I do, that the principal accelerants to stock market influence over corporations would have been there absent some SEC moves, which is when you talk about, for example, 401k and other things, and the growing influence of the immediate capital markets over corporations. One might also ask, where the hell would we be if there wasn't the pushback of Caremark and the regulatory state against the immediate pressures on corporations, and whether that isn't a balancing factor, because don't you find boards that they're under regulatory pressure, but they're also under very intense daily scrutiny, aren't they, to deliver operating results? And I wonder whether that balance comes into play, Janet.
So what I would say is, when I started as a general counsel and corporate secretary, boards really were well-fed, well-entertained, and sent home. That's not true anymore.
By the way, we hope that's true of all of our guests.
I think that Caremark made the job of the director more understood, more written down. I think that compliance at the end of the day depends on having honest, sincere, law-abiding management. I don't think any director is well-positioned to combat nefarious management. The difference, I would say, in a practical sense is if you've got basically law-abiding, well-intentioned management who's feeling an incredible stress from the short-term pressures, it's easier for me to say to a person who has a brilliant idea of how to make the short-term numbers, you can do that, but I have to tell the audit committee. And just having that extra level of check, I think, has been very helpful over the years.
So, over work, we've had several speakers come in who are now just professional directors. That's all they do with their time. They sit on 3 or 4 boards. Do you think that is the way we're going to have to move? We'll just have people sitting on boards who this is kind of their job? And at that stage, you just have professional directors who they only sit on 1 board. Like, that is what I do. Like, I manage a team and I'm a board director. My job is not.
Perfectly fair question, and we'll see how it evolves, but as a subset of that, I was talking a couple of weeks ago to the non-executive chairman of the Royal Bank of Scotland, and he told me he viewed being the non-executive chairman as taking up 80% of his time. And the question I have at that point is, what the hell does non-executive chairman mean?
Right.
If it's 80% of your time, that sounds pretty much like an executive.
What's he get paid?
He gets paid 80% of what he's worth.
I mean, well, no, but I mean, that's one of the other realities that we have now is that these inputs to capital, these inputs to cost and stuff are very high cost. And there are many of them, and their accountability circuit is, frankly, to ISS, to CII, and and it is very lucrative because those 3 or 4 directorships get them a lot of money. And so I think it is an interesting thing. One thing before we get to the question, I wanted to ask you as a matter of art in this area. A lot of directors are generationally older than even the robust young panel we have, right? And I don't know about you, but my sons can do things with technology that I'm not a droid at. How are you managing information flow, training your directors, and frankly, as general counsel, protecting them from the information dump and making sure that they're actually getting, if there's certain key materials that they ought to be able to frankly have in hard copy and retain and take notes on, are you doing it with them? Are you training them on how to take notes? Do you monitor what they do? Do you let them print out? I've heard things where people give their directors, they treat them like children. and they've been in depositions, they say, we're not allowed to hit print. And that's a great thing for a plaintiff's lawyer. And it's also, it is a generational issue, which is you got to give people information at a time and in a manner they can understand. And I'm wondering how you guys are dealing with that challenge of being able to produce an awful lot of paper to overwhelm your board, which isn't really educational. And, you know, you guys about to be you got to have times where CFOs and CEOs are saying, let's dump this on the board at the last minute. How are you all dealing with that challenge?
Boards don't like things dumped
Dump
at the
it
last.
last-
They don't. Some boards have rules that if it's, less than 48 hours before the
But
board
they're the
meeting.
ones who have to care, and the issue is they have to care enough to push back.
And they do.
And do they? Okay, and I mean, how about taking notes online and all that kind of stuff? I mean,
I think there's a variety of different practices. Some, companies require that their boards, they collect all the materials at the end of the board meeting. I think, in contrast to that, iPads, obviously, with board books and materials so that you can write, notes on your iPad, that's becoming pretty,
did the notes go away?
no.
Well, no, I've heard.
Notes never go away on an
No, I've
iPad.
heard company, no, there are people
Yeah.
who've
You
done
can-
things
you
with
can-
disappearing notes and,
Did Snapchat come out with a board?
Gonna say.
no, there
Yeah.
are. Don Wolf's looking at, Don Wolf knows what I'm talking about. There are things like that and comes in litigation. Yeah, except it just looks bad. It looks worse.
Yeah,
It's
yeah.
actually much better not to take notes than to say, oh, I took notes. What happened to the notes? Oh, they were collected. What happened to oh, these things disappear within, they are like Snapchat in some ways. They disappear within a thing. Or
I was not aware of
if a
that
director
technology.
wants to take home the financial presentation to actually read it, and are they allowed to do it?
We use Boardvantage. We print anything out that anybody requests. I mean, Boardvantage is set up so you can't print from it, but we'll
So
print
if
it out
they
and send it to you.
request it, but they're not actually mature enough themselves to
download
handle a
everything.
print function?
They're youthful enough that they can read Boardvantage.
And they can download, and, I mean, it's got the capacity to, you might as well be printing it in a lot of ways.
No, but the fact is, any of you read Moby Dick on an iPad?
Yes.
You read Moby Dick on?
Well, not Moby Dick, but I read on an iPad
Oh, okay, no,
all
I'm
the
just
time.
saying, did you take, I mean, no, it's a serious thing, because did you all know that just like a data room, that our friend, I don't know if Stuart or Joel or anybody's here, you know that they can know how long your directors spend in these things? Did you know that?
I
It's
thought
like
that was a
anything else.
function that could be turned on or off.
I think, so you turn that off, so you have,
Yeah.
that's an interesting thing. So I think I'd rather have that answer, actually, than how much time. I'll just presume it was so little that you had to turn it off. No, I mean, these are, I think, actual next level issues that we're gonna have to think about, because when you're talking about the things Larry's talking about, which is the director even knowing where to look and what the things are, and you're talking about people sharing information, there is actually part of what the hypnotizing the chicken or other is, the overwhelm people with floods of paper as opposed to highlighting risks. And I was just wondering whether you actually do think about the generational challenges of your board, the optics of frankly giving people key pieces of information that you yourself as a lawyer probably come in with tabs on and things, because you don't actually, and I'll finish, red lines. Do you give your directors red lines of key documents so that they can actually compare the evolution of the document to the previous version? You do?
Well, I mean, and something like a
It's a key
10K, I
document.
usually see a red line of the 10K against last year's 10K. I don't see the intervening 23 draft.
No. What I'm asking is, if you're giving an evolving document to a board, a presentation that tends to look similar to something that you have been working on over time, do you show them as the compliance people the same courtesy you would expect as a lawyer to actually see the evolution of the document and be able to concentrate on the changes for themselves, or,
So I'm not understanding what documents those might be.
banker presentations, audit presentations, things that are lulling because they in fact look very similar to a prior iteration, but because they are, and where you as a lawyer would never, ever in the world operate without a black line
You're in the context of a big deal.
or a special investigation.
Okay, or a
other
okay.
Evolving things
In the
where-
ordinary course.
No,
there-
I'm talking about the
okay.
bigger stuff, but in compliance areas, part of what you do sometimes is do these investigations into particular business units and others, and I'm just wondering,
There are those that want to see the drafts. They want to see, before the legal department got it, what was the audit's draft look like, then what did the legal department do to it before it goes up? And one other thing, I've seen many directors basically say, I can't read a 100-page description. I want you to cut this information as follows. Give me, risk weight your, 20 most substantial risks. I want that on the cover page. What's happening in the next, 60 days? What are the things that are right on the horizon? What are the things that are less so?
well, and that's what I'm asking Dick a little bit about, because sometimes from the standpoint of, there's a little bit of balance. You guys are a little bit the school marm, and that's part of what you do. It's always a risk when the lawyer doesn't want to be the lawyer, or the audit, the internal audit is. How do you do that thing to make sure that your board actually gets high-level informative information when it's so easy to actually because you're actually not delivering the stack of paper, you're just adding it to the flood. I mean, I don't know about you, the worst thing to me is to get to the airport, and you're about the airport, and then you get the email with the 18 attachments.
Yeah.
And you're like, what the, and if you're what do I do with that, right? And I'm saying for board members, there's always a temptation, and I'm wondering whether you all as general counsel, part of your pushback is to make sure that your directors are getting the kind of information Larry's talking about, which is actually directing their attention to certain things and not just adding at the last minute.
You lose credibility if you don't, right, over time. If you're not seen as, trusted and reliable, you're not gonna be very well regarded by your board, I think.
But have you guys been in situations where frankly you had to be that voice because it's not clear that the CEO really cares? And the fact is that if the directors are happy with their walnut chocolate chip cookies, you have to be the one, is that?
Yep.
Absolutely.
Yep.
By the way, I've been watching Billions so that when I retire, I'll be equipped to be a showpiece. Should we, Michael, did you have a last question? And then you can close it.
What exactly are you telling the people who are on this committee? Are you telling them, in a sense, look very, very hard at systematic and sustained intention? Or if it fails a little bit on systematic and sustained intention, just let it pass by. It's not going to be lost.
I think what Michael's saying is, are you actually saying to them, you should be very, very careful and pay a lot of attention, or we're going to put you up to the line where you can be sure that.
Don't worry, once or twice is okay.
Yeah.
But just don't do it, too many
And
times.
that's where I come back to my point, which is amplified by the young man's comment about the professional directors. These guys don't want to be close to the line. They don't want to be embarrassed. They want to look good. And frankly, if you said, I think this is enough to let you squeak by.
But I think, Michael, what Janet is saying is that for them, the liability is to be radioactive on another nominating committee, to be in the papers where you're out of the network. And I think what Cy maybe is saying a little bit is that can actually lead to a societally counterproductive thing where things that are responsible risks, that are malum se risk, malum prohibitum risks, not malum se risks, are not looked at and forthrightly taken in an open fashion because they don't want to fly. They care more about being in that professional director circuit. And
They've got a risk-reward calculus that is very different than the company's calculus or the shareholders' calculus.
And they're also in a situation sometimes of where a tendency towards paralysis has to be understandable because there's probably the potential for being sued regardless of whether you take a step in this direction or this direction or don't take a step at all, right? And I assume that's frustrating. You know, how do you react when you tell them that whatever you do, you're probably likely to get sued?
Well, that makes it easier in some ways.
Do the right thing.
The right thing, yeah.
But I think that's when they also say the law can be a bit of an ass, right?
They're fully convinced of that already.
They're already, on that high-minded note, that the law remains an ass. And anyway, can we thank our wonderful panelists? And I think. The,
It'll be getting right downstairs shortly.
And we will get you promptly to the train, size on the 8:30, we'll get to, we might even end 5 minutes early, we'll get to the table. The bar will be, if you can get your drink and get to the table, the bar will be open during the dinner.